Is it okay now?
Yes.
Okay. First of all, I would like to thank the Weidenfeld Trust, as well as all of you, for offering us an opportunity to talk about an important development, not only in peace building, but also in international criminal justice, which is transitional justice. I have the pleasure to moderate this event on the launch of the book that my friend and Weidenfeld scholar Djeyhoun Ostowar has published on transitional justice in peace building. You may have come across the term transitional justice in various contexts, and it's important to remember that almost all post-conflict societies are faced with a fundamental question of how to address justice in the aftermath of mass atrocities or conflict that might have occurred. And as a concept, transitional justice encompasses both judicial and non-judicial mechanism, legal and social mechanism, and it could range from an array of mechanisms or institutions such as international criminal tribunals, truth and reconciliation commissions, as well as other settings that are more grounded in the local experience, as we have, for example, in the case of Rwanda Gacaca Court. I have studied transitional justice from the approach of the participation of victims in international criminal justice as one of the actors or stakeholders in the transitional justice mechanisms. From the excerpts of the book that Djeyhoun has provided us, and I'm looking forward to the opportunity to reading the book. And I would like to congratulate you, Djeyhoun, for actually publishing not only an important book with regard to transitional justice in peace building. So you have contextualized it within a setting of empirical work that you have done in 3 specific contexts: Kosovo, Afghanistan, and East Timor. Without further ado, I wanted to start by asking you perhaps the first question. Most of the research on transitional justice has often been guided by a theoretical framework of, as you have noticed, of some neoliberal impositions or neoliberal understanding of what transitional justice is. And I noticed that in the abstract, you focus that although there is some criticism that is levied at this approach of transitional justice, it would be unwise to discount it that as the dynamics of these neoliberal thoughts have actually shaped what we consider transitional justice nowadays. So my first question is, why did you particularly choose these 3 settings of post-conflict societies: Kosovo, Afghanistan, and East Timor?
Thank you very much. Thank you very much. May I start by saying, in general terms, how happy I am to have opportunity to get in touch with old friends, meet some new friends. Really delighted to have this. Warms my heart to see some familiar faces, but also to engage with you, and also allow me to say that I think it's so fitting for me to have it is the first real book presentation while the book is still in the production phase, because this project actually started very much during my time in Oxford. Although I had already been engaging on transitional justice before joining Oxford, mostly academically. It was in Oxford, and very much thanks to the Hoffmann scholarship that I managed to build further on this particular interest and passion, I could say. And specifically, I was able to travel, in my case, back to Afghanistan, because originally I'm from Kabul. Traveled to Afghanistan after a long period of time to do research and conduct interviews, which eventually was one of the building blocks for this project. So I just wanted to, mention for answering the question, Rudina, which is of course a very valid one, starting perhaps indeed with the cases. When we do social science, international relations, political science analysis that is comparative in nature, we often tend to use tools and approaches and methodology that is considered valid in a lot of for example, have something like the most similar system, most different system design, based on the premise that are either very, very similar cases, and then you examine one or multiple specific variables that are different among, and then you try to generate explanatory based on that. And the other version of most similar cases design, where most different cases design, sorry, that is where you look at situations that are very, very different, but which may be common in that one variable of interest or multiple variables of interest, and then you try to explain again general explanatory causal relationships. In the book, I say that even though there is, of course, a lot of merit in these approaches, it is oftentimes also difficult when speaking about countries to work within those parameters, and that for the purposes of this specific book, for the specific question that I'm addressing, that is about the claim regarding liberal peace, external imposition, that it makes sense to focus actually on cases that are most often cited, most often brought up in examples and arguments about liberal peace. So in order to have a conversation about whether or not we can talk about liberal peace, liberal justice, whether or not there is a very strong level of imposition in real empirical situations, why not take those cases that are referred to anyway by those oftentimes very established scholars and commentators, and look at them more deeply and more thoroughly. And that's what I try to do with Kosovo, East Timor, Afghanistan. These are not the only cases, but are among the most frequently cited cases in the literature on liberal peace and liberal transitional justice. So that's that in a nutshell.
Excellent. As you know, one of the difficult points, or let's say situation faced in post-conflict societies, is that you have almost competing objectives. On one hand is making sure that you secure peace and stability. And on the other hand, it's addressing the issue of human rights, as well as having some context of justice that needs to be pursued. What I found quite interesting studying, I've taken different post-conflict societies as case studies, but you are right to say that there is a common thread that goes through all post-conflict societies, and these dynamics between securing peace and stability versus, to some extent, addressing issues of human rights and accountability. It's always very difficult task for any transitional justice mechanisms. And my question to you would be, how does Kosovo compare to Afghanistan and to East Timor in terms of striking this balance between peace and security and human rights and accountability?
In short, it differs in important ways. All three cases differ in ways, and this shows some importance and I will try to explain. So, but before jumping into the specificities of the cases and comparison, Because also comparison is not the main aim of my book. My main aim with this book was to engage in that discussion that is presenting very critically transitional justice as part of peace building, being liberal practices with little regard to the local context. So you're absolutely right in pointing out that in most situations there is this dilemma, this old, often discussed, perhaps already by now too old and outdated discussion of peace and justice, peace versus justice, first peace, then justice. This debate has been there for a very long time. And it's true because, of course, in most situations, I see today in my daily work that focuses on Yemen, how complicated that is, that there is an inherent tension between pursuing just accountability and pursuing but also, as I show in the book, there has been some movement there. We have seen, first of all, on the kind of more policy level and the policy discourse, that things have changed, that the understanding has moved. We saw in the 90s already, where there was a kind of almost a very explicit linking of peace and justice by the Secretary General in the famous agenda for peace. Then later explicitly by the next Secretary General, Kofi Annan, in 2004, with his very important watershed document and report on peace and justice, where he says that justice and peace don't need to be contradictory forces. They can be mutually reinforcing forces, that you need one in order to achieve the other. And then you, again, in my book, I also actually start with these examples where I also mention Kofi Annan, the next Secretary General, who said that we have reached a conceptual breakthrough where peace and justice are as those contradictory forces, and we're about peace and what form of justice. And perhaps I would add there that we were also talking at that time about what type of justice and when exactly. So the timing of justice is very important. And then allow me to just finish that point by saying that we've seen since then a certain decline in that conversation and in embracing of peace and justice as mutually reinforcing forces. The current Secretary General was already a couple of years ago acknowledging that the human rights agenda is on decline. By extension, the transitional justice agenda is in decline, because it very much depends on the acceptance and embrace of human rights. And this has to do with the anti-liberal turn in the world, with the rise of authoritarianism. And so we're finding ourselves in a particular point. And then, finally, to come to your question about important commonalities and differences. Well, as I said, despite differences, and especially of Afghanistan compared to East Timor and Kosovo, because Afghanistan represented a case that is significantly different from internationally led transitional administrations in Kosovo and East Timor. Despite the differences amongst all three, and especially between Afghanistan and those other two, we see a similar sort of process happening across board, where the assumes, at times explicitly claims, imposition external actors doesn't really hold. The empirical experiences in all these three cases show a very, very different picture and relationship, where you have a whole range of actors influencing in various ways transitional justice outcomes, either by helping to establish institutions if they were not able to do that and if the external actors were in the lead. Then throughout the implementation process, we see how their interaction, action, agency feeds into the overall process. And in my book, I try to give as thorough as possible examination of various mechanisms in each case, where this is the case in different ways, of course. It is playing out differently in each mechanism. To make it a little bit more concrete, if you allow me just to give one example, and that's an example that I unfortunately wasn't able to thoroughly examine because it was, at the time of my research, still an ongoing process. But I know that Rudina, you have done further research on this topic, and you've also spoken out about it. The establishment of the specialist chamber for Kosovo, specifically to address the violations committed by the Kosovo Albanian part of the society and of the warring parties, and specifically the Kosovo Liberation Army, KLA. And this mechanism came quite late in the process of transitional justice in Kosovo. It was in 2015 that the parliament in Kosovo adopted a decision in which this was established as a physical presence is operating under Kosovo law, and it's this case shows very well what from the very beginning this mechanism.
Can we just stop you a second? We've got a problem with your sound, Djeyhoun. Is there anything you can do to try and improve the sound? You keep dropping out at rather critical moments.
Oh, thank you for saying this. I wasn't aware.
But we really quite often through your answer, you've disappeared. Part of it, I think, is when I think it's good when you sit forward and are very clearly speaking at the.
Allow me to do one thing. If I start speaking again, do you hear me?
Yes, but we don't see you anymore, which is a bit of a pity. I mean, we don't have to see you, but it's much nicer if we see you.
Yes, let me try again. And now?
Well, speak a bit more than that.
Yes. No, but I was asking about the...
In television, we say, what did you have for breakfast? I mean, we need us to hear a bit more.
What about the image? That was what I...
Yes, we can see you and we can hear you much better. I think that's a big relief. Yes, I was getting a bit worried.
Okay, so thank you so much. Thank you so much, Alexander, because I wasn't aware, and indeed, my answer would not, be useful if you can.
Exactly, you should give your example. The other thing was that you broke up in the middle of your explanation about right at the beginning about peace, and Rudina might like to pick up on it because I actually think we should just repeat some bits of that. Rudina, would you like to do that?
Indeed, and maybe I will pick on the example that you brought from Kosovo, because that is a classic example where you see this experimental nature of transitional justice mechanisms. And that in a way points to that inherent tension. It's an aspirational idea to have, both peace and justice implemented fully on the ground immediately after a conflict that taken place. However, as you might have noticed from your empirical research in Kosovo, what has transpired in a way after the establishment of the United Nations mission in Kosovo, which was later replaced by the European Union legal mission in Kosovo, we have had almost 15 to 20 years later, the establishment of a special crimes court known as Kosovo Specialist Chambers, trying to address crimes that took place during that phase where the UN was implementing this peace and stability and some form of criminal trials, as UNIC trials, as it was known at the time. Meantime, one could ask the question, why did it take 15 years, a change to the constitution of a sovereign country, as Kosovo is nowadays, to establish a court that to some extent, puts all the efforts that were done before in a kind of a big question mark. This is not in terms of whether there is need for justice, as I'm sure if justice called for it, but why now? And the Kosovo is an example that could help us illustrate, and I hope in your book you have come up with some normative answers or like a roadmap that could be implemented in different post-conflict societies, obviously by keeping in mind or shaping it according to the nature of the conflict and the needs of the society. But my understanding is that we need more of a general and grounded approach to transitional justice to move away a little bit from this experimental approach. Would you agree with me on that?
Sure, I would definitely agree with you. I will have to confess that I haven't provided a normative answer nor a roadmap as such in my book, unfortunately. I know that my employer, the Minister of Foreign Affairs, and my colleagues would probably be also quite unhappy about that, and they would have preferred a roadmap or a set of answers. That was not my purpose, and I think the aims of both my research, obviously, but also of this book, were, if you will, more modest. Before you can come up with a roadmap, before you can speak about normative part of this conversation, when I'll be happy to come back to it in a bit, it is really critical to have a fact-based, empirically grounded, and honest conversation about what it is exactly that is happening with a transitional justice process, and what have we seen in very important instances such as Kosovo. But of course, Kosovo, Afghanistan, East Timor are not the only places where transitional justice was attempted. So what I try to do is kind of to address certain general prevailing claims that exist about the empirical reality that have turned into almost polemics or self-fulfilling prophecies, where a lot of people who argue that transitional justice, should be, either dismissed or be not part of the processes of peace building, that they kind of too conveniently, sometimes for political purposes, rely on those sorts of arguments. I have nothing against, calling out on the deficiencies, problems, and dilemmas of transitional justice, such as with any other mechanism attempted in the process of peace building. We have to be honest about it, and in fact, transitional justice is far from a straightforward process. You rightly say it's been experimental, it's been ad hoc, it's been anything but clear and uncontentious. If you look at all of the sets or all of the mechanisms that are understood and described as transitional justice, we know that the practice has been problematic. Take truth commissions, tried in South Africa and elsewhere. There is quite a bit of literature saying that some of the mechanisms and attempts led to re-traumatization of victims. Look at the reparations. You see that they are not able oftentimes to provide full cover for all those who've been affected, so they remain partial. Has been tried in El Salvador, Afghanistan, amongst others, Uganda as well. Look at trials, obviously very clear and most easy to comprehend example where prosecution stands in stark contrast or serious contrast with trying to forge a peace agreement with oftentimes the same people that are to be indicted if you pursue prosecution. So basically, I could go on, but in order to have a more better or a more successful, better approach to transitional justice, we need to start at the beginning, and that's namely to try to understand the processes. And when it comes to this specific example of the specialist chamber, for those in this chat that may not be familiar with the case, perhaps it's good to mention that the specialist chamber came, as I mentioned, in 2015. in a way, has closed the circle of retributive and prosecutorial measures that had been already in place in Kosovo in relation to the larger context of the former Yugoslavia. So already in the 90s, early 90s, during the Yugoslav conflict, the ICTY was established, a special ad hoc tribunal for the former Yugoslavia. Then the conflict in Kosovo was mainly in 1999, but as this conflict really erupted, the ICTY was in part used as well to try to address part of the grievances and problems in that conflict. Then once the conflict was concluded, or was concluded through an international intervention, a number of other measures that Rudina was referring to were established. The UNMIK process led by the UN, ULEX process led by the European Union, a lot of them, if not all, focused on prosecution, very much ignoring other areas of transitional justice and reconciliation. So, and then there was a view, not fully deserved view, that those other measures didn't focus sufficiently on the violations committed by the Kosovo Albanians, because the narrative in Belgrade and also under supported by some others was that it were mainly the Serbs who were prosecuted at the ICTY, and similar with UNMIK and ULEX. Again, both Rudina and myself know that in reality it was not necessarily the case. But eventually, what I tried to show that when it came in 2015, as you rightly said, Rudina, it was an experimental ad hoc process. It was anything but a planned, coordinated, in advanced, stipulated or kind of a drawn out approach. It was a combination of things that went in a chain reaction type of relationship, where you have an important person, former chief prosecutor of the ICTY, Del Ponte, writing and publishing a book called The Hunt, in which she publicized violations that were not addressed by the Kosovo Albanians. This was then subsequently taken up by the European Union, where an investigation was started under the leadership of Dick Martin. And this kind of led eventually to a chain reaction in which there was no other way but for the same external actors that initially shunned or avoided creating a mechanism like that to finally do it. They eventually put a lot of pressure on the Kosovo parliament, mainly to go ahead with this mechanism. So it's kind of without, what I'm trying to say is that without, in this case, the agency, and without the intervention by not external actors, but in this case, more what I call them transitional justice promoters, without their involvement and instigation, this special mechanism would never have been established at all.
There are so many aspects of the Kosovo Specialist Chambers one could focus on, and of course, questions on legitimacy, the structure and the nature of the court. It has been served to the people of Kosovo as a local court, although it has all the nuances, let's say, and elements of almost what we call not even internationalized court, but actually an international court, where chambers, let's say, the court itself is run entirely by internationals applying Kosovo law, actually outside the territorial jurisdiction of Kosovo in The Hague. And perhaps you may have heard that the prosecutor of this court made a public notice of the indictment that the prosecution would like to bring against the president, the current president of Kosovo. So we will see how that will develop. I wanted to focus a little bit more on this intertwined concept that transitional justice encompasses, such as establishing accountability, seeking truth, fostering reconciliation, and equally importantly, the fourth pillar, which is providing some form of reparations. Within this experimental nature of transitional justice mechanisms that have been applied or that have been established in different post-conflict settings, we have noticed that it would be pretty impossible for any mechanism to address such demands and achieve such objectives. The courts, which have the primary focus on establishing accountability, quite often treat reparation and reconciliation, even the concept of truth, the notion of truth, as byproduct of the judicial process, not necessarily as the main purpose. And would you consider, or let's say, would you think that there is a need for different instruments that complement each other? And perhaps when we think of transitional justice and peace building, we ought to consider more of a comprehensive approach and a strategic approach to transitional justice.
Mm-hmm. Yes, short answer, yes, for sure. Maybe to just mention on the previous point of discussion, even though indeed the book was already in the writing stage when the last step by the specialist chamber, namely the indictment of President Taci, happened. I do mention that in the book. I do also mention in the book on this specific mechanism that the jury, well, in this case, literally still out, and we don't know how this mechanism will play out. We also, by the way, based on the track record and the politicization of judicial prosecutions in Kosovo, up until that point, with UNMIK, with Erliks, to a lesser extent, based on my research with the ICTY, we can say that this process most probably will be very, very complicated. That gaining cooperation, actual cooperation from the Kosovo parties will be very difficult. Making sure that the victims and witnesses can participate in the process without being afraid of intimidation will probably be hard to guarantee. And that there will be some mingling, political mingling from different sides to steer the outcome into particular discussion and direction will probably be unavoidable. And on the question that you're raising, a very important question on the need for a more strategic approach. Yes, as I said, in my book, I don't necessarily argue for any approach. I don't provide a normative answer of how transitional justice should look like, which mechanism should be pursued, nor who should be in charge of any of those processes. That said, my personal view, my personal opinion would be that yes, that any process that is being established under the label of transitional justice or peace building would benefit from more strategic thinking, from better coordination, from forward-looking, and that whether you're talking about prosecutions, truth commissions, reparations, vetting. Another very important element is that you actually try at early stages to consider both opportunities and risks that will ultimately be on the road of implementation. The first task is oftentimes just to get sufficient support from relevant parties to establish a mechanism in the first place. That has proven to be very difficult in most situations and had been dependent on, if not luck, but on a kind of almost if not, well, definitely not random, but on a very complicated set of factors, political will, resources, and so on and so forth. So once you agree on that, you're far from done. Once you establish the institution, and let's say you want to have an international court, even if you have the premises, the mandate, and everything, and you start the operation and fill the premises with the right capacity, both in terms of professional capacity as well as technical capacity, then you're still not done, because you need to take into account, and this is, I hope, where my book does offer useful insights, is that you need to take account of the protracted nature of transitional justice mechanisms and their implementation. Is that along the road there will be influences by different set of actors, sometimes uniting around a shared concern. For example, parties that don't benefit from a particular truth seeking mechanism because that mechanism may expose their role in the conflict, or by certain transitional justice promoters that may promote a certain institution which may not be taking full and proper account of the realities on the ground. For example, the same prosecution which may be in certain places not very suitable. So you will know, and you should know, based on the track record and empirical experience, that this will happen, and that coordination, to go back to your point, is crucial throughout. And know that the transitional justice mechanisms will alter, will change, they will be malleable, as I call them in my book, by virtue of the through the interaction, and by virtue of being dependent on that interaction of a set of actors, and certainly not only external actors. If that's too vague and abstract for others in the room, I'll be happy to elaborate. I can imagine that this discussion can sometimes become too abstract.
It is quite socio-legalist in nature. As a lawyer with my own research, I have realized that this type of research in post-conflict societies, quite often, it's not a departure from legal theories, but you have to approach it more from an interdisciplinary settings, which Oxford definitely encourages. And it's fascinating to see that in the context of post-conflict societies, you see not only this legal mechanism, but you try to address from a socio-legal standpoint what are the most promising issues, and at the same pressing issues, and at the same time what form of transitional justice mechanism ought to be established. One thing we ought to agree that there is no such thing as one form fits them all, and any transitional justice mechanism has to be tailored according to not only socio-legal mechanisms, the needs of particular society, the nature of the conflict, but also, quite importantly, as I've realized also in my own research, the needs of victims of the conflict. And in that context, I wanted to ask you a question. The transitional justice has shifted more to a victim-centrist approach, where a greater stake in the process has been given to victims of mass atrocities. Although, again, this has been a grand aspiration that, especially in the context of courts, as one form of transitional justice, have tried to address, again, this has been an experimental stage. When we deal with the concept of truth, for example, providing the forum for victims to tell their stories, quite often in the setting of a court, that's never in a narrative form. And quite often, victims, whether they choose to be victims as witnesses or victim participants as a third party, they again only provide answers to the questions posed to them. So there are also contentious issues with regard to the shortcomings or the lack of reparations. My question to you would be, while we have seen this shift to a more victim-centrist approach to transitional justice, do you think that reality on the ground, especially in the context of the empirical work you have done in Kosovo, East Timor, and Afghanistan, do they match to, I wanted to say normative approach of transitional justice, but do they match to the paradigm, let's say, of transitional justice?
Thank you, Rudina, for very good and important question. I'll try to answer by, I think, picking out a few elements from my book and earlier conversations I had about the research with many friends and colleagues in the field of peacebuilding transitional justice research. So what is interesting is that transitional justice and more generally discussion about peace and justice has had a very interesting journey from a time when, you know, it was dismissed, or human rights and all approaches were dismissed by and large as not compatible with peace building and peacemaking efforts, to, as I explained earlier, to an embrace. But now we're finding ourselves in a place that definitely has much less room for enthusiasm for human rights and transitional justice. So in that sense, this is part of, I think, part of the explanation, that we are seeing a turn away from accountability, from perpetrator-centered approaches that are, let's say, on the other side of the scale, compared to victim-centered approaches. The reason being, in part, you know, because of this. Partly, it's also a very natural and positive process where there is greater attention to the place of and position of victims. So these things have gone hand in hand. Greater recognition that we need to have victim-centered approaches, and at the same time turn away somewhat from, as I said, from human rights and transitional justice. And what we see even in my practice as a diplomat today, I see some organizations that go as far as not mentioning transitional justice at all, thinking that this is a too sensitive term. Let's instead, as you say, focus on victim-centered justice. Well, you know, you can debate and argue about that, but overall, I you know, to come back to your question about normative part of this discussion, I do think that this is important and a good development in its overall direction of having greater attention for victims. The questions you can ask about this are many, but one of them is definitely whether courts are a suitable place for drawing attention to victim stories. As you were pointing out, I think there is a particular way in which victim testimonies and victim narratives will be dealt with in the court setting. Oftentimes, because courts by nature are about prosecution and about establishing legal facts, they will be interested in not the larger discourse and narrative and the feelings and psychological part of the suffering, but in the facts, and in those facts that can be used for legal purposes. So I know we've seen instances of that attempt. I remain quite skeptical, and I think I'm not the only one. There are quite a few who have spoken about it, who say that perhaps we need to have much more better and better designated and more suitable avenues where victims can have their story told. And then we go back to the mechanisms of one of the mechanisms of transitional justice, namely truth commissions. This was, you know, in a way attempted already for a few times, more than a few times in different contexts, and also quite a long time ago. We saw them attempted in the 1990s in South Africa, most famously. But there are many examples. I was just the other day looking again at some of the experiences of Truth Commission, and there amongst them are Sierra Leone, Kenya, definitely East Timor, as well as you know, it will be described in the book, Sri Lanka. And by the way, a good scholar to look at for this particular part of story would be Priscilla Heiner. She wrote several, you know, important works providing an overview of truth-seeking mechanisms, and this is a perfect example, one of them perhaps examples, but it's definitely a perfect example of victim-centered justice.
Thank you so much, Djeyhoun, for these very insightful thoughts. I would like to open the virtual floor to other attendees, and please, if you have any questions for Djeyhoun, do not hesitate to ask them. I guess they will write to you, Temitope, or?
Yes, so I can. Yeah, so people, you can either leave your question on the chat for Rudina to say and then to moderate, or you can raise your hand and I will point you out. So I have maybe one question to start for Djeyhoun. I'd like to draw the focus to Afghanistan and maybe East Timor in particular. So could you, this might be an impossible question, but could you maybe in a minute or two just say what a truth commission actually is and what it's supposed to do? Because I think some of the people in the call might actually not be familiar at all with this concept. And after that, my question then is how, besides, with the Truth Commission and all the other instruments of transitional justice, how do you see the different external actors that are involved in maybe Afghanistan and East Timor? In comparison, how do those external actors influence what sort of transitional justice process happens in the country?
Do we take multiple questions or just starting with this one? I'm in your hands. Okay, I'll start with this one then. Thank you, and I'm also sorry that I think we both have difficult names, and I struggle still with pronouncing your name. If you could help me.
Temitope.
Timotophe, yes. Thank you, Timotophe. I didn't want to make a mistake. I already once wrote it wrong. I realized in the emails. Anyway, so yes, so for Afghanistan and East Timor, I'll just mention this, that even a very short glance at those cases would reveal that there is a much more complicated picture with transitional justice experiments, attempts, implementation, than what would be acceptable under the premise of the prevailing narrative of liberal peace, where external imposition is an important part of. In East Timor, you see what I describe as parallel justice and multiplication of justice mechanisms relating to the events of 1999 post-referendum violence, where both in the neighboring Indonesia, that was a colonial or occupying power in East Timor before the referendum, as in East Timor that became independent after the referendum, you saw kind of a concurrent and competing process of establishing transitional justice mechanisms. You have prosecutorial processes that were in many ways similar to what we saw in Kosovo, but you also see something that you almost don't see in Kosovo, a very strong effort in establishing truth-seeking mechanisms. And truth-seeking is based on the premise that you need to find out the truth and establish, document the truth about what happened in order to avoid relapse of the conflict, in order to address the grievances that there may be of the population, and in order to establish an authoritative version of events, in order to avoid later on rewriting of history or using events in other ways that we've seen in history a lot of times that happening, including in the former Yugoslavian context, where, for example, the Second World War events were used as an explanation or as a mobilizing narrative. So you see this. What is interesting in East Timor, you see that the number of mechanisms, in total 6 different mechanisms established in both, but focusing all on East Timor, and that there, for example, with specifically truth commissions, you see that at one point these are the local actors that take over the initiative and take over control of the processes. The initial truth commission that was established mainly by the UN and designed and conceived of mainly by the UN, the so-called CAVR, it was operating for a few years until the government in East Timor and the government in Indonesia realized that this institution is proving very inconvenient to them, that the East Timorese government realized at one point that there is insufficient international political will to engage and to punish those involved. And in fact, the Truth Commission was also pointing to some of the violations committed by the East Timorese. And the Indonesian government was already from the beginning not interested in doing prosecution and transitional justice, because they were party to the conflict, and the violence and post-referendum large-scale violence actually happened with their role and with on their watch. So there, at one point, you see the process completely turning upside down, where the local actors, in this case, the East Timorese and the Indonesians, established their own Truth Commission, the so-called Commission for Truth and Friendship, that were supposed to supplant the East Timorese initial commission. So, and then Afghanistan, very briefly, you see there a similar sort of pattern where change in the relationship between the local actors and the international actors, so domestic and external actors, has a significant impact on how transitional justice is being implemented. So in Afghanistan, at one point early in the intervention, it was possible to start a large consultation process where an institution that was just established, the Afghan Independent Human Rights Commission, which, by the way, is led by, at the moment, by a former Weidenfeld, well, still a Weidenfeld scholar, Shahrazad Akbar. She was in our cohort. She's now chairwoman of the Afghan Independent Human Rights Commission. Together with the UN, they conducted a large-scale, countrywide survey, almost countrywide, because the Taliban were, of course, present still in some parts. And they concluded that transitional justice was very important, that people want accountability, want justice, and so on. And then early on in the process, because the dynamics were different, you see the government also adopting a transitional justice action plan, which, you know, amongst other things, said that they need to work on measures to prevent impunity, work towards accountability, and so on. Fast forward a few years, and the dynamic changes. The local government is becoming more and more proactive and independent, or in opposition to the international actors, including the US. And there you see that they're at one point taking over the process by not extending the mandate of the Transitional Justice Action Plan implementation, as well as issuing an amnesty law that, you know, basically cancels accountability measures. I know there was another part to your question, but I hope this answers at least part of it.
There are a few questions that we have received, Djeyhoun.
Okay.
I will ask a question that Natalia Brigago, I hope I pronounced your last name correctly. She says, thank you so much for sharing your research. I was wondering if you have any thoughts on what role, if any, addressing economic impact and socioeconomic justice has had on TJ. I know that in East Timor, for example, both the conflict and the fact that the UN forces were forbidden from spending money in the country had some impacts in that sense.
Could you elaborate, the person who asked that question? The UN was prevented from spending money locally?
Natalia said that I know that in East Timor, for example, both the conflict and the fact that UN forces were forbidden from spending money in the country had some impact in that sense. So basically, if I understand correctly, it's addressing the economic impact and socioeconomic impact that transitional justice has had in specific post-conflict society, in this case, let's say in East Timor.
Okay, thank you very much for this question. I have to confess that I cannot speak to this particular part of kind of the context in which the UN was forbidden to spend money, or in general in UN-led peace building or international-led peace building and reconstruction and state building. We see a whole economy around international actors, where, you know, they are often times the ones with money, with more money, and they can spend, and there are all kinds of services from, you know, drivers to technicians to and so on. In East Timorese context, you're probably right. I didn't look into that particular angle. But the larger question, I understand, and I very much agree that one of the kind of underappreciated aspects of this discussion, which was lately called to attention by many scholars, is this social dimension, economic dimension. Is that oftentimes we forget that the conflict cannot be addressed, or the root causes of the conflict cannot be addressed if you don't look at the socioeconomic conditions that led to the conflict in the first place. This goes beyond the immediate group of victims, perpetrators, and when, for example, you speak about reparations, you oftentimes refer to victims who suffered directly, either because they lost a relative or they themselves suffered an injury and they need some sort of a material compensation. Oftentimes it's not enough. In some situations, it went hand in hand with an apology or with some other symbolic measures, such as erecting a museum or a memorial site. But completely agree, and I think it's important, and in some instances this has been called, including in Yemen, by the way, is that it is important to look at social injustice, and that you need to create a situation in which there are less incentives for parties to engage in conflict in the first place.
Great. I see two hands here. One is from Sarani and then Shabana, but I will invite Sarani first. So can you speak, Sarani?
Sure. So thanks so much for sharing all this kind of insight. You mentioned really early on in your context that there's a lot of kind of a lot of growing force against transitional justice, against human rights. And I was wondering, so I come from Sri Lanka, and I would say that definitely that the political will is not particularly for, very, very positive towards transitional justice. And I was wondering, so in a context like that, where your political will and maybe even your kind of majority of your population sees it as a negative thing almost, how do you work towards these objectives? And indeed, can you really achieve everything that you set out to if you don't have democratic backing for it?
Thank you for this question. Very, very important, very good question. And my book and my research indirectly answers, or almost implicitly answers this question, which, amongst other things, tries to show that transitional justice, like most other processes, is not static, is not fixed. It's not what Huntington, the big scholar from the 90s, still of course, but in the 90s he wrote, amongst others, that if justice doesn't come early in the process, it doesn't come at all. So if you don't, in the transition, if you don't start with persecution, you can basically forget about it. I guess what my research, amongst other things, and of course there is a lot of other research out there that would show that this is in reality not necessarily the case. Even if you look only at this narrow question of prosecution and accountability, you cannot assume that the absence of the political will now will be also the situation. It's common sense, but oftentimes forgotten. What is important, however, if you are on the side of the transitional justice promoters and those who want to have this materialized, that you work on the foundation, the building blocks, the basis upon which transitional justice measures could be built. We talked earlier about truth-seeking, documentation. These are typically measures that are considered overall to be less controversial. That even when there is not enough political will to do something more ambitious, that there could be, either by support from international actors, donors, or on the local level will to engage in an exercise like that. And as far as I know, Sri Lanka is one of those countries that has done partly that process. So that could provide a good basis and foundation to later on find a moment when there will be a window of opportunity for NGOs and human rights workers to engage with the relevant actors to push for a particular measure. And by the way, it doesn't have to be, again, prosecution only. As discussed also with Rudina, the experience with prosecution has shown time and again that it's not always easy to implement it properly. It will remain contentious. I'm not arguing against, but all I want to say is that there are other avenues that could perhaps be explored. But what is important, and this to tie it back to other questions, is that whatever is happening, that it is reflective of the desires and wishes of the population. Otherwise, and now we're speaking of the normative side of things, otherwise there will be never full legitimacy for those measures if you don't do that on a demand sort of basis.
I will invite Shabana to ask your question.
Thank you, Djeyhoun. It's very wonderful listening to you present your book and your research, and greetings from Kabul.
Thank you.
Sarani's question and your answer to her question partly addressed my question to you specific to Afghanistan, but I will ask a follow-up question to that. Given how the transitional justice process has been or has not been implemented in Afghanistan, especially in the past 19 years, and assuming you're following the intra-Afghan dialogue in Doha, can you speak to how hopeful do you feel about both the negotiation process and following that a justice that a lot of Afghan people, and I'm talking about the ordinary people that are desperate to get?
Oh, thank you for this important question. In short, unfortunately, I'm not too hopeful for short and immediate term. I don't, at the same time, become fully dismissive of the possibility of transitional justice emerging kind of more successfully in Afghanistan. And a positive, one positive development there is that, we have voices in Afghanistan, including and perhaps primarily the Afghan Independent Human Rights Commission, that try to keep the issue of justice and victims, specifically victims' interest, on the agenda. As you will have seen, the statement by the Afghan Independent Human Rights Commission right at the start of the inter-Afghan dialogue was about that. And I'm also encouraged by the fact that they're participating also in the discussion. They're invited to the delegation. How much their recommendations, voices will be taken on board is hard to say, based on the power dynamics and the realities and the parties involved. And I'm not talking, by the way, only about the Taliban, but also of the government representatives who have been everything but supportive of transitional justice. We can assume that there won't be much enthusiasm for inserting it into the peace agreement. What I would hope is that there will be no closing of doors for this agenda to play a role in the follow-up stages. So what we saw, just as a brief background, we saw in 2001 when the intervention happened with the Bonn Agreement, that justice was mostly absent from the negotiations. Then we saw, as I tried to describe very briefly, is that we saw the kind of a up and down trend on transitional justice in Afghanistan, with lately things being on a very minimal level. There's certain small avenues of hope. The recent decision by the ICC, the International Criminal Court, to open formal investigation into the situation in Afghanistan, and as I mentioned, the Afghan Independent Human Rights Commission, office of the High Commissioner, and some others that are trying to keep the issue on the agenda. So yeah, power dynamics and political will won't be there, unfortunately. But I hope, and again, this is also one of the implicit messages of my book, I hope that those who have agency, and these are not only the parties I mentioned, but also in bilateral and international donors who subscribe to the overall human rights agenda and transitional justice agenda, provide support, provide political backing, provide the necessary resources in order to move forward.
Thank you, Djeyhoun. Before I ask Esther Nishutik's question, Natalia has sent a clarification here. She said, thank you for your answer. I got the information about the UN spending in East Timor from a bio on Sergio Vieira de Melo, which mentioned that being unable to spend money in the country, basically in East Timor, was his greatest frustration, and this distorted local economies. These economy-related tasks were left to UN Development, the World Bank, and the IMF, which worked slowly, so the mission was blamed for leaving little tangible behind. And then I will ask Esther's questions, who says that, can you please speak more on the need for strong mental health and trauma counseling systems being embedded in working hand in hand with the transitional justice system, short-term and long-term post-conflict? What would this look like? If I could add only one thing, and I'm sorry for using my position as a moderator to add, but I have done research in Cambodia, which is another post-conflict society and has implemented a form of transitional justice mechanism through an internationalized court named Extraordinary Chambers in the Courts of Cambodia, established 35 years after the crimes that had been committed in Cambodia, which saw 1.7 to 2 million people who died between 1975 to 1979. Maybe you have seen the film The Killing Fields. But in the context of Cambodia, there have been a number of, let's say, projects and programs that have been implemented to address the issue of mental health and trauma counseling, and which has been seen as a vital component trying to address not only the victims' needs, but also to help the transitional justice process, especially in preparation for victims to participate as stakeholders in the transitional justice mechanism, basically in the court. But I will give the floor to Djeyhoun to elaborate a little bit more in the context of the question that Esther has asked.
Thank you. And also for this very good example and an interesting example. And unfortunately, there are not that many examples of a clear focus on addressing traumas and mental health, the mental health side of this well, very huge priority and undertaking that is known as transitional justice, or any form of process that allows to address grievances from the past. I would say that it's a very important and perhaps even very promising avenue to look at and research further, because I think transitional justice also could benefit. The discourse, the policy could benefit from, if not creative, because there's been some experiment with that, but at least different from the usual approaches. And it's clear that this should be part of the kind of undertaking of a lot of countries where large-scale violations took place. It is also strange, for example, to assume that by providing someone with material financial compensation, if that's the single mechanism that's implemented in a certain country, you kind of can do away with the violations that took place, or assume that now the victim will just move on. That it should be common sense that you need to provide resources, you need to provide attention, and there needs to be political backing to help the society to move forward. And there, I guess I would go one step further and also say that indeed perpetrators perhaps may need this part of support as well, especially if there's been a process that is considered legitimate in order to allow them to reintegrate into society. Those instances such as Sierra Leone, but certainly South Africa, where truth commissions were central in the transitional justice effort, they contained oftentimes this almost this trade-off, or this swap, in which a confession was taken in return for well, amnesty, and perpetrators could, by confessing, move on and not be afraid of being put on trial. But then again, I think there, if you accept this as a society, perhaps it would be also wise to engage in the necessary mental health and other approaches in order to allow that reintegration to happen.
Are there any other questions that we could ask to Djeyhoun before we close up our session today? I think from what I see here, not yet, but I take this opportunity to thank you, Djeyhoun, greatly. Okay, so Esther said, thank you for your answer. I did not know that about Cambodia's transitional justice system, and will do so. We'll do some more research. I'm from Rwanda, and that's the context I'm speaking from. And 26 years post-conflict, we are seeing that trauma counseling should be an essential ingredient in the systems. And I could say, Esther, it's absolutely right. The nature of genocidal regimes actually destroy the very social fabric of the society. And you can establish not one court, but you can establish many transitional justice mechanisms, but sometimes it's the passage of time that could, I see that Sarani has raised her hand there, but it's, there are a number. You can't, let's say, compensate for the passage of time and what reconciliation and some form of healing that need to take place for society to move forward. And there is not a single court or a single transitional justice mechanism that could fix that within whatever period of time they're operating on the ground or whatever their mandate is. So the counseling and the trauma centers are quite essential, especially, like, for example, in the context of Cambodia, you had 1/4 of the population that had perished, like, and the most intellectual part of the society. There is no doubt that anybody you meet there had lost someone, if not many members of the family, and therefore trauma is deeply rooted, and you need not only counseling within the first year, but you would need to stretch this over a considerable period of time to have some impact and effect or positive effect for victims to move forward. I will give the floor to Sarani.
Sure, so just to follow up on the questions that have been kind of the discussion. So it seems that, as you said, in answer to my earlier question, that to make this really work, you need to have a popular demand. You need to have the people asking for it so that there is that legitimacy. So what are the kind of, and as you said, it might take time to go there. What are the kind of things that can happen in a society that take you to that point where you're actually demanding justice and demanding that accountability? When does that become the popular will?
Thank you for this question. Oftentimes, it's well, actually always, not oftentimes, always, it's so context specific and context dependent. What will happen in a particular instance? Will there be a popular upheaval? Will there be a demand? It all depends on the intricacies of the context and what may or may not happen on the political in politics of that country. But what you see from most transitional justice experiences so far, and not only those that I examine in the book, but also others that I've come across, and I think will be true for Rudina's research, is that it's probably wrong to expect that the society just by itself can and will be able to do it fully on its own, unorganized, without an initiative by a certain party that is well placed to do it. So there can be, of course, I don't dismiss this possibility, there can be some sort of an organic movement for that. And ideally, this for transitional justice, this would come at a time when there is avenue or possibility for political change. Maybe a new leadership can come, or there is election coming where this can be put on the political and media agenda, election agenda. So this is a very clear way in which the population can raise these sorts of issues. But oftentimes, there is a need for involvement of NGOs, relevant organizations, donor community, to help understand what it is exactly that the population want, even if the demand is not so clear. In some situations where there may be a case of a repressive regime, or where there may be not so much space for political activism and free speech, or simply because there may be too many other priorities that people are suffering of or from, for example, the socioeconomic problems. In those sorts of situations, it may be necessary, and often is necessary, to proactively engage in that conversation through surveys, through other means, and try to understand and map the real wishes and desires of people. And I have to add here that it is important to have that kind of process done thoroughly, as much as possible, not politicized, as much as possible through proper, transparent process in which issues of justice and accountability don't become a reason for further division and political pressure or political tension. So if there is a thorough process that can be, at least in its approach, accepted, then you can have perhaps a meaningful discussion either now or later about what this means in terms of clear and concrete avenues of addressing the demands of the people. I hope this answers the question.
Definitely.
Yes, thank you.
I think these were the questions that we had thus far. Djeyhoun, I'd like to thank you for the very insightful and thoughtful contribution to the discussion today. I, for one, look forward to reading your book, and I'm sure all the other participants here will be equally eager to read a book on transitional justice in peacebuilding. This is an important contribution to the field of transitional justice, and you have contextualized it within the field of peacebuilding, which is very important. So you have seen it from a greater scope than that of just a transitional justice mechanism. But thank you so much. It's been a pleasure to moderate the session, and it's been also great to see other Weidenfeld scholars, new Weidenfeld scholars who have joined. I believe some of the Weidenfeld scholars here are from the current year or the current program. But I also noticed that we have Diliana, I hope it's Diliana from our cohort who is based in Washington.
Yeah, she's connected very, very early. I think she's in the States now. Diliana, are you there? Yeah. So thank you.
I was also trying to see whether, I didn't manage to see the full list, but whether there are people from our cohort, but definitely thank you once more for this initiative, for having this series of book and other presentations. I definitely enjoyed the sessions that I attended as audience. I hope this was well, useful and interesting. And I also would very much like to thank Rudina. It was easy to do this session with a moderator who herself is an expert and also a friend. So thank you so much. It's so lovely to see you again.
You are most kind. Thank you indeed. And I look forward to meeting you in person somewhere, sometime, but hopefully soon. Hopefully very soon. Yes. Thank you. Okay.
Thank you both. Thank you, Rudina, and thank you, Djeyhoun, for facilitating this today, and for also for making yourself available. So there will be more events such as this in the coming weeks. So you can go to the link that I just posted in chat. We have I'll put them there as soon as I confirm them. And registering also should be quite easy. So I hope to see many of you, in the next week and in the weeks to come, and if you would like to also speak about anything, just reach out and we'll organize that. So have a good continuation of your afternoon or evening or morning, and see you soon.